Hey everyone, and welcome back to Topics of Discussion. We got another solid update on the Bainbridge Township Dog Park shooting case, and this one includes some brand new scheduling details you want to hear. I'm your host Ron, and I'm glad you're here. Let's jump right into what's happening in Geauga County Court. Just a quick recap. April 21st of this year, 55-year-old Marine veteran David Matai was shot in the lower right back during a heated political argument at the Centerville Mills Dog Park. The man charged is an 80-year-old man, Emmanuel Matthews. Both were armed. 6 shell casings were recovered, and the case has been moving forward. On June 10th, Matthews entered a formal not guilty plea, waived his right to a speedy trial, and had his bond conditions relaxed. House arrest is gone, but he's still on GPS monitoring and banned from the dog park. Now the fresh development, June 15th, court is scheduled an attorney conference for this Monday, June 22nd at 1 p.m. before the Judge Carolyn J. Paschke. And according to the court filing, the meeting will take place over Zoom, with the defense attorney, the special prosecutor, and Paschke all joining remotely. So, you ask, what exactly happens at an attorney conference? It's basically the first step in a major strategy session of the case. The judge, the prosecutor, and the defense team will discuss discovery progress, pending motions, and very likely to start exploring whether this case can be resolved without a full trial. And that brings me to something important I want to explain to you. In Ohio, the vast majority of criminal cases, 95 to 98%, never go to trial. They're resolved through plea bargains. The rule that controls how these pleas work is called Ohio Criminal Rule 11, or Crim R11. Here's why it matters. Before a judge can actually accept a guilty or no contest plea, they must personally address the defendant in open court and make sure the plea is knowing, intelligent, and voluntary. The judge has to explain the charges, the possible penalties, and most importantly, all the constitutional rights that the defendant is giving up, like the right to a jury trial, the right to confront the witness, and the right against self-incrimination. Any plea deal also has to be stated on the record. The judge isn't required to accept this agreement, but in most cases, they do. So in this case, if Matthews and the prosecutor reach a deal down the road, Judge Paschke will have to go through this full Criminal Rule 11 colloquy before accepting any plea. Right now, Matthews' defense team, led by Ian Friedman, is being very proactive. They've already filed a full demand for discovery, motion to preserve any and all video and audio, evidence, and more. Clearly preparing a strong self-defense strategy. We still have 2 very different versions of what happened that day in the parking lot, and the physical evidence will be a crucial part either way. Here's my question for you today. With an 80-year-old defendant, a veteran victim, and strong evidence on both sides, do you think this case ends with a plea bargain, or are we headed for a full-fledged trial? Drop your thoughts in the comments or send a voice note. I read and listen to almost everyone that I get. I'll be keeping a close eye on next Monday's Zoom meeting conference. As soon as I have any more details, I bring you the next update. If you enjoy these ongoing case breakdowns, please hit subscribe, leave a quick review, and share this episode with anyone who likes following real court stories. It really helps the show grow. Thank you so much for listening to Topics of Discussion. Stay curious, stay safe, and I'll talk to you soon.